Slide 1 tells you where we are, and slide 2 tells you a little about who we are. Thanks for attending. As the man just said, this is Chapter 11, Industry Focus on Marketing 2024. That's not such a mouthful. It's episode number 3 in the Chapter 11 Industry Focus series. And there you go. You can see the 3 episodes in the series. You can catch episodes 1 and 2 on demand. You can do that by going to financialpoise.com if you do not want CLE. And you can do that by going to West Legal Ed Center if you want CLE. Working backwards a little bit in terms of slides. Slide 8 tells you what the series is about. Slide 7 summarizes some of the issues we may touch on in this episode. Slide 6 gives you the name of our names. Candace Klein, Cobus Vanderzel, Ken Yeager. I'm Jonathan Friedland. You can see short bios for each of us starting on slide 29. 1 slide each. Financial Poise frowns on infomercials that don't want you to sit through 30 seconds on each of us, so you got to go look at the slides. Regarding the slides, the way we'll incorporate them into this webinar is that when I ask a question that touches on a subject that a slide addresses, or when a panelist's answer does, I'll try to call out the applicable slide number and I'll try to turn to it. We'll see if I can, what's the expression? Chew gum and walk at the same time. And to be sure, you can listen to this webinar and get a lot out of it. It's designed so you can just listen to it. But to get the full benefit, you should really listen to it with the slides in front of you. Okay, that housekeeping is done, and we can go to the first question. And the first question I will assign to Candace. Candace, one of the prior episodes in this series focuses on retail Chapter 11 cases. What are a couple of issues that exist in a typical Chapter 11 of a retailer that don't exist, or at least don't predominate in the same way in a typical case of a manufacturer?
Yeah, so thanks, Jonathan. So retailing is pretty different from manufacturing. So one is that the retailer, when you're talking about the distribution of goods, right, they're at the end point of that process. So they're going to be concerned about, for example, going out of business sales, and flipping probably the entire company in a 363 sale that's going to leave a lot of stores closed and liquidating, conserving cash, and also looking to try to monetize other assets, which really aren't that many in a retailing environment, but that could include, for example, leases. They may have advantageous leases. Obviously, one of the goals of a retailer bankruptcy is to get rid of bad leases, and they have them all over the place, right? So think of malls and outlots and all of the like. So for a retailer, a significant amount of work will be done upfront in the case, usually around some kind of liquidation and sale. In a manufacturer situation, they may have a role that is incredibly important in a supply chain, right? So it's not necessarily, you might have a change of control transaction like a 363, but you want this thing to be operating as a going concern. So you want to keep the production moving. You want to make sure that the financing's there, that employees have some comfort. You're going to be communicating in an entirely different way, right? The retailers may be dropping employees quite aggressively. Here, in a manufacturing standpoint, you probably, if you are in the mode of a going concern reorganization, you probably want to try to keep things going, and you'll line up that support even before you file.
Okay. Cobus, Ken, do you have anything to overlay at the moment before I move on?
No, I think that covers retail very well.
We don't need gratuitous compliments. Each one takes a second and a half. Efficiency. I was just handed a note telling me I forgot some other housekeeping items. So real fast, a quick PSA. not a PDA. A PDA would involve me saying something like, "Can I love you?" I suppose that might be an example of TMI as well. Slide 5 is a disclaimer. It's an important legal disclaimer, important for us, not for you. Well, sort of for you. We're not your retained professionals. You're not our clients. The webinar is for general information and educational purposes, but it doesn't replace the need to hire professionals to address specific situations you may be involved in. That's PSA number, the PSA on slide 5. Then there's one on slide 35, which reads, well, you can see what it reads. It gives you the email address and other information about Financial Poise, the producer of this webinar. It also gives you a link to sign up for its free weekly newsletter. I can honestly say that newsletter has been life-changing for me, and I recommend it wholeheartedly. And finally, slide 27. I'm getting to it. Slide 27, questions or comments. Look at slide 27. If you have questions about this webinar or other Financial Poise webinars, if you have questions about the substance of this webinar, you're of course welcome to reach out to any of us, but you can also actually reach out to Financial Poise, which can sort of ferret or convey the question to the right person. Okay, so back to the program. And Ken, this one's going to be for you. Let's reverse the last question. So that would mean I'm asking you for some examples of issues that are more likely to exist in the Chapter 11 of a manufacturer than that of a retailer.
Yeah. So Candace started to touch on this and really got into what I'm going to call the labors and materials issue. They're at the center of everything in manufacturing. Certainly we talk about unions and pensions being potentially involved. We get certainly old school, but that's also
slide 15, audience.
Yep. The need to, the other thing too is supply chains. You cut off a supply chain, and I think everyone got a great example of this during COVID. You break or bend that thing, and it takes a long time to repair. It is not a trivial matter. We have companies that gave up their allocations and lost those things for a year or more. We have people who lost their suppliers because they couldn't take the materials and the supplier went out of business. And lots of things like that. Very sensitive in terms of that supply chain. You got to keep it moving. Unlike a store where we're getting, we'll stop, and then later you come back and say, "Oh, just kidding. We're going to get some bunch more people in there, and we're going to run that store again."
Slide 17.
Yep. And then you also have environmental issues that seem to trail behind manufacturing. If you ever follow these things, you'll see over time we learn more about chemicals, and then we have pronouncements that now a new chemical or chemical has been around for a while is now considered a bad chemical, and you might have been a good operator until now. Now you find out you're a bad operator. So environmental issues do kind of follow along the supply chain, if you will, in manufacturing. The other things I'll say is,
and that's slide 18.
The other thing we'll say about the world is manufacturing is complex. Supply chain is not the only part of it. You can get into things that will go international, and you're trying to pull materials from all sorts of different places. And now we are getting into contracts that cross country lines. We have currency issues. It goes on and on and on. The only other things too I'll say is just talking about kind of bouncing off of regulatory items. You can deal with workers' comp issues in the manufacturing space, and OSHA reigns large in these spaces. And when things are starting to collapse or workers aren't happy, you can start to get reported, and it can be more complicated. Certainly the magnifying glass is on you.
Any overlay to Ken's answer to my last question? Moving on. And this is sort of, Cobus, this will be to you. And it's sort of, there's a risk of asking the obvious here, but for sort of context, looking at the forest rather than the trees, why are these issues, in plain English, why are these issues more likely to be present in the context of a manufacturer than, present or at least prevalent than than that of a retailer?
Yeah, thank you, Jonathan. That is a good question. Manufacturers are very labor intensive. Their processes are very complex, and they have very complex processing plants to take raw materials and process it into various subcomponents and store them and reassemble them again. So the amount of labor involved make it prone to unionize, because there's a lot of trades of the similar skill that is really ideal for a union process. And that's why you find the unions. And from the unions, then you get big pension issues that flow out of that because of this labor intensive environment. And so you have the issues of defined benefit versus the defined contribution issues that can be managed during a bankruptcy process. But you also have very fixed supply contracts. I've worked in a chemical industry, and in this industry, sometimes there are only one offtake agreement for an entire factory's output, or you have all of your input coming from one specific supplier, but you have that under contract. And sometimes your commodity prices can just play havoc on you, and you have to renegotiate that, and that can be done in the safe haven of a Chapter 11.
Thank you for that. Overlay, guys? Staying big picture, anything? Okay. Moving us on, and this will be the last, I promise, little break, interlude, if you will, because there's still a couple of quick notes I need to make. It's better than if I did it all up front. That would have been more boring. So quickly, I promise, slide 3 is about Mood. Mood is a cannabis dispensary online where people can buy legal cannabis. That's a sponsor, a paid sponsor. We love them. Slide 4 has 2 sponsors. Type to Learn, a very good product for parents to get their younger children, and Max Asset, which is relevant to those in the corporate restructuring and solvency field who need to conduct auctions. Finally, well, not finally, I think I got 2 more. Slide 33 is one of our other sponsors. It's actually a related company, Daily DAC, offers all sorts of information about this world of distress, insolvency, bankruptcy, and the like. And slide 34, a couple of pretty decent books that are available for purchase through Thomson Reuters. Okay, no more interruptions. Next question, Candace, audience, slide 20. And Candace, 2 types of agreements gained particular notoriety, at least from my vantage point, in the context. I first heard about them as a fairly experienced restructuring attorney, but it wasn't for the first few years of my career until I had to deal with some auto industry distress in the early 2000s. Notionally, these agreements are not unique to auto. Read my mind, and I'm assuming you're not looking at the slides. What agreements am I thinking of?
Yeah, so in the automotive industry, and by the way, they're becoming more popular in aerospace or other similar sort of OEM, tier 1, tier 2 type supplier, just-in-time supply chain industry. So if you have that sort of, vertical, highly integrated supply chain, you're going to look at these agreements. So the first one is an accommodation agreement, and this is between using automotive, OEM, maybe a tier 1 supplier and a lower tier supplier that's in distress, right? So you have this integral supply chain, and this may be a supplier that is the sole supplier for a little component, and they are financially troubled, leaned up to the hilt. It's a disaster waiting to happen. And so what this accommodation agreement will do is basically buy some time. It enables the OEM customer to get more involved with the supplier's activities. On the financing side, for example, they can create opportunities for additional liquidity. They might get involved with the senior lenders and start making advances, get involved at the senior loan level. Of course, they're the ones sitting with the first liens on everything. So everything the OEM's doing is going to come in in a junior position, so they might want to try to improve there. And then they make some arrangements with the supplier, right, as part of the accommodation agreement. So if the OEM is going to give, maybe some forbearance and some financing, maybe they're part of the financing packages that the OEM will pay the raw material vendors directly, right? Again, you're trying to create liquidity and handle cash. In accelerating payments, right? So if you were 30 days, maybe now you're 10 days, right? And you're trying to just get cash into the supplier to try to make sure that that supply chain is uninterrupted. And by the way, that is part of the agreement, right? So, you may even sole source with that supplier and they have to keep delivering. So you have performance expectations, in order to maintain this degree of accommodation. It's not without limits. So if the supplier blows this too, then we may go to the next level of agreements. And those are access and security agreements. And what those agreements do is they provide the OEM or the customer to the distressed supplier a direct access. I mean, it is exactly what it means, right? Self-descriptive, direct access to assume the manufacturing of those parts, whatever is necessary from an operation standpoint. And it defines the terms around that right of access, right, to take over operations directly, and how long that may last. It could last, a year. It can be, pretty prolonged. It also means security. So what may be occurring is the development of, some inventory, escrow, right? So you're starting to get more parts on hand to try to deal with some of this potential disruption. And again, you'll get liens, and they're probably second, but the point here is that you have the customer taking an increasing degree of control over the financial and operational affairs of the supplier.
Great. Overlay, guys, at all?
No, that's good.
If we were gonna, hey, what did I say? If we were going to get all bankruptcy geek talk, wouldn't you agree that, and I don't want to get into this now, but Candace, this whole area implicates concepts like dip lending, critical trade, the earmarking doctrine, right? Each one of these areas goes into, in one way or another, the conversation around accommodation agreements and access agreements. So should we take a moment? Anyone think we should take a moment to explain the the OEM tier 1, tier 2 dynamic a little bit in more granular fashion, or do you think we covered that well?
Let me throw a couple of points in there, Jonathan.
Okay.
First off, we do have the customers, but we also have layers of customers, and one might ask themselves, not from this industry or aerospace or the agricultural space, is also kind of got these kind of tierings. What's going on in there? Why do we need all these people? The average car that runs around in the US has 30,000 parts in it. This is a nightmare on a good day, right? And when you run into now we've got and not everyone, you can't make all those parts. So you've got to build supply chains, and you have to rely on experts in all sorts of different places, or technologies. And places becomes really an important part of that, because now we start to look at ourselves being overseas for certain stuff, maybe because there's a cost, or because there's an access to a raw material, or there's a particular piece of technology that works better for us than something we can find in our home jurisdiction. And so now we have OEMs, or original equipment manufacturers. That's the brand, the Fords, General Motors, and Toyotas of the world.
Or Apples, right?
Yep, exactly. Who are relying upon a tier 1 supply of expert or direct, we'll call it direct suppliers, who have aggregated those 30,000 parts into components, into systems that are very complex. And then they're in turn relying upon a group of people who have the niche manufacturing capabilities, then some of them are deeply reliant on the automotive space, and some are like, oh, the automotive guys are here. That's nice because we're also working on other things too. And then you can get down all the way down to, we talk about basic, plastic manufacturers or people creating glass, in very simple, what otherwise would seem simple at the beginning becomes very complex. Then you throw that all into the international complexities of different bankruptcy laws and different jurisdictions. You throw that into the tariffs and trade regulations. It's just kind of crazy stuff, and the exchange rates that follow with that. And now you have this primordial ooze of craziness that needs a structure. And this is the kind of stuff that Candace is talking about, where we're trying to get, those accommodation agreements or something in place so that people all know how to work together and know that there's something going on. They can all rely on the system continuing to work, because it hasn't been working very well so far.
Okay, thank you. Anyone else? Okay, so with all of that as some context, let's back the camera up. Cobus, I'll call on you for this one, just to give you the heads up. You get a call from a client, a manufacturing company, obviously, because that's what this webinar is. It tells you that its biggest customer, also a manufacturer, which accounts for about 50% of its volume, and I'll pick a number, 30% of its profit, just filed Chapter 11. What are some of the first questions you're going to want to ask and things you're going to want to tell your client?
Yeah, that's a typical situation. So from the numbers that you mentioned to me, 50% of the volume and 30% of the profit, it looked like we may be undercharging a little bit there. So, but we'll leave that technicality for later if it is relevant. The first question is, how much do they owe you? And get in contact with the trustee or the debtor and confirm the pre-petition payables and what procedures they will offer or have for post-petition supply. So it's also important to look at section 503B9 of the bankruptcy code. The product that you shipped in the last 20 days has administrative claim status. So that's important to show the client what amount of their claims has this status and which amount is subject to loss or subject to the bankruptcy process to play out. And then the post-petition claims, if you continue to supply with agreements from the debtor, often it is on cash on delivery. Sometimes you will trust the debtor with a payment plan because now professionals are in charge. And the good news here is you need to remind your client, this is a Chapter 11 filing, it's not a 7. So often a client may feel, wow, this is bankruptcy. But this is the intention here is to reorganize and to continue operations. And you as a supplier to this entity may be a critical supplier, you may not be, but you need to look at all of your options. How critical are you to their supply? Can you use some of your raw materials in other products for other clients? In that case, it's less of a risk, but if it's all very specific, then of course you need to get really good commitments from the trustee or from the debtor to give you really good terms or cash on delivery for any future supply. And then you must, I always say, never let a good crisis go to waste. Take the 13-week the cash flow model that the company has. Most companies that are close to trouble have these models, but you need to, as a professional, as a certified turnaround professional, really take them apart, put them together the right way, show the client exactly their cash exposure and what is the worst case and a best case under this scenario. And then I normally challenge the client to say, let's use this crisis as an opportunity. Often you can use Chapter 11 as an opportunity. They do want to continue supplying, and you can sometimes get price increases passed. Sometimes you can get better payment terms than in the past, and you can use that to your advantage. But also you can use that crisis to really improve efficiencies with the help of professionals in your company, so that you use this crisis as an opportunity to lift your own company's performance level up. And of course, you need to look at if a WARN Act needs to be filed, if more than 50 people is at risk from your 13-week cash flow analysis, then you need to say, be ready to do that when the time comes. And make sure that, well, if you have accounts receivable insurance, then that is good. But if you don't have, it's probably too late. You need to negotiate good terms on your post petition supply. Those are some of the main pointers I had, Jonathan.
Thank you. Overlay. I'll bet on this one. You guys have some overlay. Who wants to give some overlay?
Yeah, I like the comment about accounts receivable insurance, because I have seen that basically provide trade creditors, some recovery in Chapter 7s where there otherwise would be no recovery. So that seems to be, be worth the money. And, I think is probably prudent to have. I think that the other issue is you might decide even before filing. I mean, think about it. There's nothing that compels you to just really keep trading. So if you have a client, or supplier, anybody, right, in your supply chain, wherever you are, and they're in breach and you're concerned about their financial distress, I mean, self-preservation is a business strategy, so you don't have to put yourself in harm's way. And I wouldn't be too afraid of, oh no, it's going to create a preference liability. So what? It's better to have the cash, and negotiate it later. And that's only a 90-day look back, right? So you might have already changed trade terms, 6 months or a year ago. Sometimes the financial distress is a very slow train a coming, and you got some time to manage it. So I would encourage anyone, and notably in the manufacturing realm, is if you see signs of distress, and even if you're getting these assurances that, you're going to get paid and they're doing the best they can, consider moving on. Because sometimes, I'll use an example, you may have shipped the goods and the goods, went overseas or in a jurisdiction that you can, you just can't remarket it, right? What do? I mean, now you have a bunch of parts that are labeled metric for the EU and you can't sell them in New York. So there may very well be some hard credit decisions that need to be taken before you're sitting with a proof of claim in a bankruptcy case.
Any other overlay from any three of you?
I'm going to throw it in on what Kobus also said. He had to pass by it quickly, but he mentioned a 13-week cash flow model. This tool, which is not for this necessarily for this webinar, is incredibly powerful. We often refer to it, and hopefully no degradation to anyone's religious beliefs, but the Bible, the glue, the holding item that actually keeps everyone communicating on where are we going and where are we, because it is a model that actually focuses on cash and what is happening to cash, which is the only vital organ at this point that is, everyone's trying to hold on to, while we're trying to, I suppose, try to keep supply chains going and put people employed. So that thing is incredibly important to everybody. Everyone who's in this situation probably needs to have their own to verify what's going to happen strategically to themselves. And if you are someone who is critically looking at, suppliers who are struggling, you'll want to look at their 13-week cash flow model. So it's a tool of communication. It's very powerful.
Yeah.
Thank you. One thing Kobus mentioned was a WARN Act notice, and just to provide a little bit more detail on that, there's the WARN Act itself, which is a federal law, and then there's what are called the baby WARN Acts, right? Mm-hmm. And so you got to look at the number of, and basically all the laws, the state and the feds Fed law basically says if you have less than X number of employees, you're exempt. You don't have to worry about it if you're going to close a facility. But if you're not exempt, you got to give notice about the closure, about well, not really, it's not really about closure, it's about a mass layoff, right?
Yeah, no.
And what some non-experienced practitioners sometimes get wrong is they are thinking about the federal WARN Act itself, which has a higher limit. So, let's say you have 90 employees. Does anyone know what the federal limit is? The federal
It's 100 employees, which
100.
is
So you might say, oh, I only have 50. I don't have to worry about it, but you got to check the baby WARN Act, the WARN Act that may or may not be in effect in the state at issue. And it often has a lower number, meaning more protection for the workers and more more of an onus on the company to give notice to, under more circumstances. Okay, so let me gen up a new hypothetical and I'll turn to slide 21. I think it's probably as relevant as any other slide for this hypothetical. Ken, this will go to you. Let's assume you're the CEO of an OEM. So your company sells stuff to end users or maybe to wholesalers or retailers who in turn sell to end consumers. I don't know that it really matters let's assume it does both. I don't know that it really matters for my purpose. An OEM needs to protect its supply chain. And we talked about that already a little bit, but give us some specific steps you're going to take to do just that.
all right. Well, we've unpacked some of the tools already, but let's throw them all together here. I've got a supply chain, and we'll use our OEM topic. I've got 30,000 parts per vehicle I'm trying to pull in from across the globe to make these things ship. I am going to want to protect every end of my supply chain. And one of the things that I'm going to go to is liquidity. And that's kind of the overarching answer here, which is I need to put a warm blanket of cash over my supply chain and make sure it flows first. And I'll come back to Cobus's point about efficiency in a second, but I'm going to look for capital, and I'm going to find capital in a couple of different ways. But one of the first is I might, let's assume that I'm not in bankruptcy. I'm going to run up and down Wall Street and LaSalle Street and try and find myself lenders or alternative lenders that I can bring to the situation. I might find myself jammed in a corner and be the kind of person who let's say is already highly levered, or his ratios are out of whack for what Wall Street and LaSalle Street want to play in. And I might need to go and file for bankruptcy.
Don't go there yet, though,
Okay.
because you're anticipating my next question. Let's assume
Right.
you're reasonably healthy.
Let's stay out. What I'm going to try and do is get that financing in place and show the supply, and then start protecting the supply chain, providing maybe through accommodation agreements that were brought up earlier. I'll look at my 13-week cash flow model. We'll start there. So I've got some capital, and I've got to go through my 13-week cash flow model and determine where am I having kinks, who is not pulling through, and what's causing me to have variances and delays, which is what I'm concerned about. And I'm going to look at those supply chains and decide whether I'm going to put support consultants, workflow people in place, or am I going to say, okay, this is a time for accommodation agreements, like Candace was talking about earlier, to try and say, okay, let's try and, I don't think the supplier is going to make it, so let's go ahead and start making the obvious choices to improve the supply chain. Or I might reverse what Cobus was saying earlier and say, I am paying an awful lot of money for what I'm getting out of this particular supplier. I'm going to go squeeze them, and to bring some efficiency back to my cash, back to the cash flow of my supply chain. All of this in an attempt to protect what's going on.
Mm-hmm.
Thank you. Overlay. Anyone?
Now, there's often more opportunity than a company can see themselves if you bring the right professionals in, and that is what a good 13-week cash flow. Once you rebuild that cash flow, you can really show the company opportunities that they have not seen, and then get the right professionals to execute on that.
Thank you. Okay, so now we can lean in and say, let's say Ken's company is in trouble. Candace, audience slides 11 through 13 is what will implicate in some of this, some of what I think I'll elicit from Candace. But not sure, she can be very unpredictable. Candace, Ken calls you seeking your input on whether chapter 11 is a viable and a good option. What are some of the immediate questions you're going to want to ask Ken to help you make an initial, not binding, but an initial assessment of how you think things may go?
Mhm. Yeah, so you really want to get a good 360 view of what the company is facing, and that means all categories. So, what's happening operationally, financially. That 13-week cash flow is an interesting tool to start looking at what do they have in terms of even cash on hand, because bankruptcy is not free. So you need to be able to, buy into that chapter. You need to know where the lending and financing is today, the relationship with the lenders. If you're going into bankruptcy, you need to have a new facility or some way to pay for the administrative costs of bankruptcy, either cash on hand, you're using somebody's cash collateral, you get court approval to do that, or you're getting a new facility. Is the provider of the new facility already in the bank group, or is it, for example, a loan to own situation? Somebody who might be interested in taking over the company, or potentially an insider, right? So the company has failed, but maybe one of the large shareholders has a sufficiently strong strategic interest to get more, say, deeply invested in this process. The prospect of going concern versus shutting down and liquidation, you're looking at all of those factors, whether there's litigation of any kind that is out there. So sometimes that can be a real advantage to filing bankruptcy, because you're going to then direct everyone into the bankruptcy claims process. You may already have a significant amount of pressure. When you have a lot of litigation like that, that tends to cut off other out-of-court options that you may have been considering. So an assignment for the benefit of creditors, a receivership, just an out-of-court sale. Litigation might be the straw that breaks the camel's back and puts you into court protection because of the automatic stay, which is unique to bankruptcy. I would also be looking at whether there's some opportunistic advantages to going into bankruptcy. For example, you can, assume and reject contracts, right? And if you have bad contracts, you can reject them. It gives you an opportunity to right sizing, ensure value for your company. By the way, flip side occurs too. You can assume contracts. Maybe they're favorable to you, right? You have a long-term supply contract on some raw materials that's very price competitive. And that's going to maintain, an attractiveness and a value for your company. So bankruptcy gives you a pause, but it also gives you an opportunity to be pretty opportunistic. If you have a very adversarial relationship with your senior lender, I'd say bankruptcy could be costly and challenging. If there has been fraud, bankruptcy may be costly and challenging, depends on what it is. Another question is if you want to even maintain control of the company through bankruptcy, or if you want to give it, give the controls over to someone, like a Ken or a Cobus or a trustee, right? And we have this role that has been growing and growing, which is, a chief restructuring officer concept or an independent manager concept, right? So you're taking a look at, the management team, you're looking at corporate governance issues. If there have been crazy, potentially fraudulent transfers, to equity sponsors within the last, 2 to 4 years, I might, have a little bit of worry about bankruptcy. You might look at, okay, what has been the challenges? And for that, the bankruptcy form, so you get a statement of financial affairs and you have schedules.
Well, let's not get that granular yet.
Okay, well, the only reason I'm saying that is that they tip you off on the potential causes of action. So when you're filling that out, and if you see that you have insider transfers and you have, potentially fraudulent transfers, those are questions on the sheet. So if those sorts of facts exist, then I might, look at, bankruptcy and timing, depending on the situation.
Fair enough. Comments, questions, overlay. So Candace delineated a number of factors that, if present, might bode poorly for the company going bankrupt, for the debtor. Are there other factors that matter most, if you will, if you want to take out your crystal ball and you look at a company that is about to file or just filed, and you want to, the question you're asking the crystal ball is, will this company be able to reorganize through a Chapter 11, a traditional Chapter 11 plan of reorganization, versus is it more likely to sell as a going concern, or versus, yet again, is it more likely to end up liquidating and selling, in pieces? What factors might one look for to try to just to make an educated guess as to which of those three destinations the company is headed for? Slides 25 and 26 sort of speak to this. Cobus, any thoughts?
Yeah, like Candace said, the relationship with the creditors, that's really key. But it's not about the creditors, it's about this company. The question should be asked, is this company really viable? Because when you get to the point where you're about to go into Chapter 11, it's not news to anyone. It's the end of a process of chewing glass for probably many years, where the board has been frustrated, the bank has been frustrated. You've gone through several forbearance agreements on your loan agreements with the bank and different creditors. So by that time, there's a fatigue. So it's all about, is there any trust in the management team in place? If that management team is strong and you are being killed by China as a competitive force, or there's something else in the industry, then often it says, well, you're not going to get a better management team. Something else is happening here. Let's prepare this to sell it to a bigger boy in the industry and get out of the situation. So sometimes it's dictated by that. So we use very specific tools to test the quality of the management. They're different individual work styles. We match that to the jobs they do. We use scientific tools to really understand the management team and what we have and the process that they followed so far. We match them to world-class procedures, and then you can clearly see this company is at world-class already. Not much we can do. They're being killed by China or some industry force or not. So if that's not the case, sometimes you will take it into Chapter 11, do some cleanup on contracts or some changes you can make in Chapter 11, but then go on a 363 sale to sell it to the highest bidder. And this process is very successful. A lot of companies have been doing that lately. And you can even get a partial sale done. You may identify a part of the company that can continue as a going concern, but you sell off pieces on a 363. And a final option then is a liquidation option, where once you've done, sometimes you even go to a 363, only liquidators show up. We've had that with a bike importer in Iowa. Only liquidators showed up, and it was because of a really dysfunctional family situation. So we ended up putting an interim manager in place, and that satisfied the conditions. The bankruptcy court approved it, and we were able to make a sale based on an interim manager stepping into a situation. So those dynamics will determine whether you go reorganization, exit as a going concern, or a sale or a partial sale. And then eventually there may be assets to liquidate, if not it's unlikely if you have the right professionals that the entire company will be liquidated. There are normally good options.
Thank you. Overlay, guys?
Yeah, I'll just add, what seems to be the most common use of Chapter 11 for the larger cases is that there is a change of control transaction in a 363. And so you'll do a sale of substantially all of the assets and all the employees who are being retained. Everything goes with that sale, and they'll continue to operate. So post-sale, the company lives and continues doing its thing. And what's left behind in the bankruptcy is just a liquidating plan. So while you'll see a Chapter 11 plan, that's just liquidating what's left over, including causes of action, may develop a trust. But I would say that's probably the most common use of Chapter 11 today. And if you just look, on the dockets and see what's going on, it's some flavor of that kind of liquidation. You're either fully liquidating in a Chapter 11 or you're doing a 363 asset sale. Substantially everything goes to the buyer. They operate. It might be the senior lenders, might be the landlords, but somebody's going to operate this thing. And then what's just left behind in the 11 is the dogs and cats to finish the liquidation and winding up of affairs.
Yeah.
Anything? Anyone? I'll give just a quick overlay of a couple of thoughts that occurred to me as Candace was speaking. And the distinction, that what's the expression, difference without a distinction, or distinction without a difference? So if a change of control is going to happen, that can happen pursuant to a plan or a 363. If, on the other hand, there's going to be a reorg, that actually can also happen through a plan or a 363. Sometimes it's, a form over substance kind of thing. I co-authored a number of years ago with Jamie Sprayrigan and Roger Higgins an article called Chapter 11, Not Perfect, but Better Than the Alternatives. And it really steps through this line of thinking. And it can be deceiving when we look at, I think this goes to Kansas's point, when we look at sort of the raw numbers, how many of all the Chapter 11 cases filed in year X, how many had confirmed plans and how many had 363 sales, how many had both? Unless you look under the hood, you don't really know what the real story is, because to a point, these are just labels. Anyway, I should stop because I'm getting away from practical and more into bankruptcy geek talk. Ken, you talked a little bit about the 13-week cash flow model earlier.
Yeah.
Maybe, and we have about 10 minutes left. With that in mind, is there anything else that's worth getting into for a minute or two about, in keeping with the theme of this episode of this series, about what issues manufacturing companies in particular might face with forecasting their 13-week cash flow statements compared to other industries? Anything you want to say about that?
Yeah, let me bring up two quick points. First off, Candace brought this up earlier too, which is, COVID's talked about the need to make change and pivot, right? And so whether we need to do that to a sale of a business or a reorganization of business, there's going to be a pivot. Great. These manufacturing companies are typically like giant battleships or oil tankers. They take a long time to turn. And in that turning process, we get to where Candace was, which is what's left over. It's like, oh my gosh, we're going to turn. So we're going to get rid of this manufacturing facility. So we've got to do something with the union. We have a landlord. We have brownfield. We have Warren Act issues. All this stuff that's got to be moved. It's got to change directions for the business or get left behind in the estate that needs to be settled in some fashion. And that's where manufacturers have all the, need that time to cure or solve their problems in court, because it's just way too complicated. You start telling people you're moving without the protections of the court, the supply chain may scatter. right? People just don't understand what's going on. The visibility is not there. The communication channel is not there to explain how we're getting there. And so the other thing too with the 13-week cash flow models, we talk about that, is the what I like to, the lesson I like to leave with people is like, okay, great, I'm gonna have a cash flow model. This is, everyone thinks it's about measuring cash. It is, but they also think it's dollar signs. And I like to tell people this is about the cash activities of a company. And did you or didn't you do, you said you were going to do, it's not the revenue, it's did something ship, did something get done, did something get stopped or started that needed to do that. And cash flow models is the best way to measure that activity because of the cadence, which is weekly, and because it is rooted in cash, which is to say, okay, we can, everyone else can talk about their accounting and their accruals and their what they did and what they think they did and get brownie points for trying, but cash is accomplishment. And it's when we can ground things into, and that's why it's so dang important to what we do.
It's the most, on bankruptcy might be the most salient example of the expression cash is king come to life.
Yeah,
Amen.
exactly.
So now we enter our speed round because we have 8 minutes and I've got more than 8 minutes worth of questions. So I'm gonna ask as many of my remaining questions. You don't know what they are, who they're coming to, so good luck with this. But I'm gonna ask some of my remaining questions, and you should be looking at me because about 20 seconds before I'm gonna give you a hard stop, I'm gonna touch my nose. I'm a child. So we'll start with, I'm gonna turn us to slide 19, and I'm gonna ask Cobus to answer this question. How do companies with heavy physical assets approach asset valuation and disposition during bankruptcy?
Oh yeah, this is very important. All turnaround shops are well connected with third parties. This is not something that you want to do yourself. You want to get a third party asset valuation done, and that is asset valuation and or liquidation firm that will do that. That's done this many times before. Get the objective market price. And we've often had assets in the middle of Iowa or rural Illinois or somewhere in the Midwest, far from metropolitan centers. And you must ask yourself, what's the cost of moving it to a metropolitan center where you can maybe sell it for higher value? For instance, we had a bike importer in Iowa. Bikes can easily be placed on trucks and moved to Chicago, where if you have big, heavy machinery that is semi-automated, it's very hard to sell that as a pile of parts to a bidder. It's much better selling that in place. And then you will use some kind of online auction to facilitate a wide web. And the professional you pick to be your auctioneer or your liquidation company, they will have all of these processes to properly value and to put it in front of the right people so that you have a optimal exposure and a good sale of your assets.
Thank you. I want to talk about first day motions for a moment. And before I do, I have a question about a particular first day motion. Before I do that, I want to explain for the uninitiated what a first day motion is as quickly as I can. And by the way, if you want to learn anything and more about any of these concepts, I would encourage you to go to dailydac.com, DAC. There's all sorts of articles written at a pretty basic level, very accessible, all free, about virtually everything we're talking about in this webinar and in this series. So when you file a Chapter 11 petition, I've always analogized it to chemotherapy for cancer. It kills the bad stuff, but it also kills some of the good stuff. It's the most famous attribute perhaps of a Chapter 11 petition is that it creates an automatic stay. So all collection activity ceases, and if a creditor wants relief, they have to go to the bankruptcy court and seek relief from the automatic stay. But this is where the analogy comes in. That's a little bit, it's overkill because the way the code is written, perhaps, and case law certainly has developed, is that it not only does it prevent a creditor from affirmatively saying, pay me, or continuing with litigation, but the debtor's hands are tied and it cannot pay any pre-petition debt without permission of the court. And that can be hurtful because, you know, a debtor needs to pay its employees what they earned last week if they want the employees to show up next week. The debtor needs to pay its electric bills. There's all sorts of expenses the debtor needs to make. And the bulk, a good number of the first day motions exist to basically reverse that default, because that's the debtor saying to the judge, I want to pay this group of debts, and here's why. And those are a lot of the first day motions. So with that context, Candace, why might a typical manufacturing company need a more fulsome customer programs motion than a typical retailer? Or is that even a correct premise?
Well, retailers may have, for example, rewards programs, points, credit cards, things like that, you know, gift cards. But here, because the manufacturer is integral in a supply chain, right, they may have things like warranty programs. You may have service programs where, you know, your customers can have you do, you know, specific maintenance, and that needs to continue to be available and may have even been prepaid, right, as part of the overall contract relationship. So, you know, you have a bunch of, you know, I would say, you know, after sale maintenance, long tail related to manufactured products. That's just not the same as, you know, a t-shirt off the shelf, and that can be very involved, and you want to maintain all of those programs to the extent necessary to, you know, maintain your business and prop up your valuation.
Thank you. Overlay? Anyone? Cobus, what about the so-called first day wages motion? Talk to us about that real briefly and what, actually, just talk to us about that motion real briefly.
Yeah, Section 507A4 of the Bankruptcy Code allows for priority claims for wages, salaries, or commissions, including vacation, severance, and sick leave. So basically, a trustee goes to the bankruptcy court to seek an order to authorize payment for these employee obligations and employee benefits that you mentioned, Jonathan. So you want to avoid unnecessary financial hardship to employees and disruptions to operations if you can allow these employees to continue operating and therefore protecting the cash flow of the future entity. And of course, you can also, you're not going to change your collective bargaining agreements, pensions, and union agreements in a first day motion, but that can also be done later during the process.
Thank you. So with a minute remaining, I'm going to do what we sometimes do. The fact that we didn't get to every question that I had planned or every slide is not a failure. It's just a reality. But if we had a few more minutes, what would we have covered? We would have talked more about customer and supplier contracts, long-term supply agreements. That's slide 17. We would have talked a little bit about cross-border issues on that slide 22. And we would have talked about intellectual property issues, that's slide 23. To state the obvious, and I think to reiterate something we said in the beginning, you're more than welcome to reach out to any of us. We don't do this because we're performing community service. We're doing this because we've got a selfish interest in you know, being out in the world. And the other thing you can do is you can go to dailydeck.com. And also, in particular, if you have access to, if you have an all-you-can-eat subscription with West Legal Ed Center, you can purchase past year's episodes of this same presentation where we where the past panels may have gone into depth in other areas we didn't have time to go into today. So with that said, on behalf of the panel, thanks for coming. We hope you got something out of it. And if you did, consider the other episodes in this series and the other series of webinars produced by Financial Poise. Thanks for coming. Webinars.
Thank you, Jonathan. Bye,
Thank you.
everyone.